I knew you would. Where's everybody at?
I don't know. Victor was late yesterday, so he might be late today too. And then Will didn't come yesterday, so he may still be sick.
Okay. You going to a shindig?
Nah, I already have one of them too. They got passed out Saturday.
I'm gonna take one for me and one for my wife. Let her put it up in her firm. Just for kids. You know, my wife works for Soda and Greenberg.
Oh, did she?
Yeah.
I didn't know that.
Yeah. And hey, your competition's having a party. I know for me, when people say, "Hey, you recommend a criminal attorney?" Yes, it's Rob and John.
Yeah.
You know?
They're the only two that I know in the valley.
Yeah, I mean, I'm not gonna stick my name out there for anybody else. And, you know.
Yes, I'm here.
So if you don't mind, I want to run, see if I can grab a cup of coffee and. What's doing this here?
All right, I'll leave the door open until you arrive. Is that all right? Okay. So you're the one here, and the other boys are gone. Have they been in touch with you at all?
No.
Okay.
I know Will was sick yesterday.
Right, I heard that.
So he may still be sick. But I think Victor's back at the dental office, so he may be delayed now.
Oh boy. He's working with Mom right now?
Yeah, I think so.
Okay.
Because he said he had to do things for tuition yesterday. So I was like, all right, you do what you gotta do.
Pull out a few teeth.
Yeah, exactly.
When we said to extract some money from them, we didn't mean their teeth.
Literally?
Yeah. All right, well, you've got one here, we've got one over there for now. The cold doesn't show up. Good grief.
He wasn't here yesterday either.
I know it.
I think everybody's just getting. Drucker said that everybody, like in his undergrad, was getting sick.
Well, he said he was sick, but for being a guy that's supposed to be a muscle guy and a fighter, he gets sick too often. So that's just Irene Dolan's observation.
He also pushes himself a lot more than the rest of us.
You think that's it?
Maybe.
You're very kind.
I try.
Victor's here.
Well, Victor's here.
All
No,
right.
I figured I was on my own.
No, I would have did it to you.
Coach?
I'm on time. I'm on time as long as I get in the room before.
Well, technically, he was already here. I know.
Yeah. Well, we'll make sure the video looks good.
All right.
You want still sick?
I
You didn't say anything.
you didn't say anything to me, but maybe.
All right, guys. Corporation.
This is the worst chapter ever.
I was Victor. I was telling Vincent about how fantastic our last class was. How we were. I was asking you guys to brief cases and we're in the chapter.
So it's so good to mix up for this one. We can just call it right.
So I don't know. I can just imagine what the video of that class looked like.
I'll let you know.
But you know,
Oh, so that's big. You weren't using them.
But now we're moving on to corporations, and I was gonna touch base with you guys first because I don't want to confuse you. I have a Nevada corporations outline, which I think is not all that bad, given that most of the cases we're talking about are not California cases anyway. They're out of the area, and it gives the basics, and it's current. So I wanted to maybe shoot that to you guys just so you had it and you could use it as a resource if you wanted to. But then I also have this much more thorough and in-depth outline that Judge Hop gave me and said he used it when he was here teaching the class. And but it's from like 2001.
Seems outdated.
You would think, but I looked at it and
Not too much.
generally the concepts are the same, right? We're talking about corporations, you're talking about what makes up a corporation, how do you form a corporation, all of those specifics as far as basics go are still there. So what I may do, just to tell you guys, I think if I'll just shoot it to you, take a look at it. If you find it helpful, use it. Just understand as you're reading them, you're not obligated to read them. That's not how you're going to be tested on the material. I'm going to try to write up essays off of the material we've covered. As far as multi-states, I'm told that there's a good collection of multi-states already here. I don't know if it's through the software that they have or
It's about library copies.
what's that?
They do library copies.
So, but Judge Hop said, oh yeah, there's hundreds of corporation and partnership multi-states. So you don't have to write new ones.
Well, they've had 4 years of it by now. You think they'd have a nice collection going?
you would think, but I don't know if they wrote any last year. Right, last year could very much have been
Well, the good thing for you guys is we didn't really talk to last year at all. So even if you gave us the same ones, we would have absolutely no idea.
I don't think they talked very much. I actually sat in and did a peer review of Judge Hop last year. And it was kind of sad. He was sitting there talking. Anna was over here just typing away, but not listening to him. She was typing something else. It was clear it wasn't about this case. Hilda had her nose in the book. And the only one that engaged him at all was Aaron. And why don't you guys go have a cup of coffee and talk about this stuff? And because it doesn't seem like anybody else is engaged in this process.
Yeah.
So, all right. Characteristics of a corporation, right? The central characteristics are, right, you've got limited liability. That's a huge selling point. Right, because remember, as we've talked about the various different types of business organizations, we've only gone through partnerships, and now we're here in corporations. Well, with partnerships, each of the partners are still personally liable, right? We're here, and with corporations, the shareholders, if you would, are not personally liable. The corporation itself is its own separate entity, and that limited liability is typically a good selling point for advising why you would want to be a corporation as opposed to something else. right? You've got free transferability of ownership interests, right? We've got a whole economic business set up on the exchange of stock and corporate ownership interests. Continuity of existence, right? Corporation's still there, right? Presidents retire, presidents pass away, CFOs come and go, people get fired. You're making money, you're losing money, but generally the corporation keeps moving on and you're just filling in the slots. And that sort of continuity of existence is an important selling point for why people would want to incorporate. Centralized management. Okay, yeah, you have management, basically your board of directors that are going to, make the decisions for the corporation, and they get to run everything, right? You have, clearly you're gonna have shareholder votes and things like that, and we'll get into that a little bit, right? Different types of stock. Was it preferred? Is it common? Right? Is it weighted in some way, and what impact does that have on the voting structure? But generally, decisions of a corporation are run through a centralized management structure. And lastly, you've got entity status. That's important. If you are a separate, legally recognized entity, you can sue, you can be sued. You can buy, you can sell, right? You can do most things that an individual could do. Okay, so having that sort of structure really puts in place, some of the benefits of why people would want to structure their businesses in a corporate fashion, as opposed to simply a partnership or some sort of other limited liability type arrangement.
Sounds just like to protect your personal assets and you're making enough money, you don't want to lose your mansion or anything.
Well, absolutely, right? So, when we're talking about just basically corporate law, just some things to kind of keep in mind. You're going to have a law, and as we talk about this, you're going to hear flashes back to your other classes. Right, we're going to be talking some torts. We're going to be talking some contracts. We're going to be talking some constitutional law and things like that. But just as a general rule, right, when you're talking about corporate law, how's it structured? Right. Well, where is its centralized location? Where is it headquartered? Where is it incorporated? Right. Those may not be the same place. Where it's incorporated may not be where it's brain center is what a lot of the outlines calls it. Where is their main operating principal place of business? That's a good the PPB.
That's what we learned in Civ Pro.
Right. Right. But all that's going to come into play, right? And different states have different corporate rules. It's not necessarily that just because you're a Delaware corporation, that any dispute with that corporation is going to be analyzed under Delaware law, right? It may be analyzed under California law. And California has a very broad interpretation of when it applies and what characterize what we call foreign corporations, which just basically mean non-California corporations. And what the book said, and that makes sense to me, is you hear a lot about Delaware being the place you want to incorporate.
Yeah, no.
And what they said, at least in the summary, was that's not actually true, right? If you're forming a corporation, you're probably best suited to form your corporation in the state that you're at.
Yeah.
You know, that's where you start. Delaware is a place for reincorporation, right? Once you get going, once you truly start seeing your business take hold and your corporation profit and grow, where you can start taking advantages of all the things we've talked about that makes it a good business structure. Transferring of assets, purchasing of things. As soon as you start seeing your ability to engage as a corporation more fully fulfilled, people reincorporate in Delaware. And Delaware's rules aren't all that different than, say, California's, but what they do have is stability. They have a corporate set of laws that is well informed based on the legislatures that work there, the judges that are interpreting it, because of their corporate friendly attitude. A lot of corporations are there, and those are the people that go up and are interpreting and legislating further. So there's this sense that the best corporate laws come out of Delaware, where it used to be, it was much more prevalent because of tax ramifications and things like that, where now it's just, you know, if you're a big time corporation, to say you're a Delaware corporation kind of carries a little cachet, and you have that same sort of structure and stability and reliability in how things are going to be settled and interpreted by the courts. And that's probably about as good a reason to go there as any. But it's not where you start. So what law governs corporations' internal affairs? Well, depends where you're at, right? A lot of corporations have internal documents that set up where their personal affairs are, what law governs. So they have that authority to do that. And in the absence of that, right, you kind of get into this whole sort of constitutionality, you know, interstate contacts, minimum contacts, what effect does a transaction have on interstate commerce and things like that to make a choice of law determination in the absence. And corporations don't like not knowing, right? They don't like not having that certainty. So the good corporations are set up in a structure that they know exactly where their internal affairs are going to be governed.
But so in section 3, it states still that like the normal rule is that the law of the state of incorporation will govern the corporation's internal affairs. And it says, however, some states, including California and New York, have adopted provisions which designates certain internal affairs. But then it seems like the next case gets rid of that altogether.
Wow.
So is that part of the book still right? In as much as states can still regulate certain internal affair type transactions, or does this case kind of put a kibosh to that even theory?
No, I believe that they still can.
Okay.
Okay. And that's a perfect segue to talk a little bit about Vantage Point Venture Partners. You know, I'm not much of a business lawyer. I don't have a whole lot of experience. I'm gaining that. But they were talking about a lot of corporations are funded out of
Delaware.
not only Delaware, but out of joint capitalist joint ventures where people are just throwing money to as an investment. I'm like, really? That's how I didn't necessarily, that wouldn't have been my guess that that's how most corporations are funded.
Right, the big ones are fun. They get their share partners and say, okay, we'll invest this much if you give us this. It's like Shark Tank.
Right.
We'll give you this much for this much of your company.
Exactly.
But we're part owner now.
and we want to say in the decisions.
Yeah.
And then once you get on your feet, we want our investment plus
yeah.
and we're out. And then go. And then you reincorporate Delaware and knock yourself out. So I always say that because that was something I learned. I wouldn't have thought that a venture capital type of investment would be the primary mechanism that corporations are funded under. But they say.
Yeah, because I think a bank would give you too many loopholes, right? You have to, not loopholes, but hoops to jump through.
Right, and they're saying that for most part, it's too risky for banks, and they're not gonna want to give a loan knowing that what's your income coming back? How can we base your ability to repay?
Yeah.
And you don't even want to repay, right? Whatever, when you first get started, that money you're earning, you want to put back into the corporation for growth, and so banks frown upon investing in startups. So
Yeah, for me to get a small loan took like 2-3 months with Altura going back and forth to finally get it done. So you can imagine we're trying to get multi-millions from a business.
right.
Although, like when I worked at the bank, even with corporations and stuff like that, one of like the directors of the corporation had to personally sign liability to the loan. And so no corporation ever wanted to do that because none of their directors like, I don't even know if I'm going to be here in 5 years, let alone 30 years when the loans due. Like, no.
And part of the reason I want a corporation is so
I don't
have to do this. Yeah.
So, right, in Delaware, apparently they have courts of chancery. Right, where are you at? I'm down at Chancery Court today. Right, this is a recent case, relatively speaking, and you know, who knows what type of court structures that other states have, but I just, you know, it's neat to think of how they're set up and what they call their courts, and maybe they think, you know, superior courts and whatnot on that California refers to aren't all that impressive. But what's at issue here with Vantage Point be examined? Right, we've got well, first off, who are our two parties?
There are two different corporations that are going to merge.
Right.
And so XMN had like two different kinds of stockholders, and these are all so confusing.
Yeah.
Mm-hmm.
And so Vantage Point, one of them had two different kinds of stockholders, and the one group of stockholders wanted to have a say in the merger, but under the Delaware law, they wouldn't have. But under the California law, they would have. And so those stockholders wanted a determination under California law that XMN was a quasi-California corporation, and therefore they had to follow the code sections in California that would have differentiated how the shares could have voted.
Right.
And Vantage Point said that, or no, XMN said that they were incorporated in Delaware, therefore Delaware law should control them.
Right.
And the Delaware court, the Chancery Court, said that the two laws were in conflict with each other, and that California's law was unconstitutional on the Delaware corporation, and so therefore that provision of the California code didn't matter, and that they had to follow the Delaware law.
Right. And in doing so, right, these venture capitalists who put all this money up for preferred stock that would give them
More of
a vote over common stock, just got their shares diluted. Right? Delaware said, nope, you know, and that's what they were fighting against. right? They wanted to have more of a say than they thought they had paid for their ability to have more of a say. Okay, so ultimately, right, the court in their choice of law rule, right, which they call the internal affairs doctrine, right, they found that doctrine enshrined in the Constitution, right? Seems like a stretch, right? And they cited to CTS Corp, the Dynamics Corp, and said that was, what they were relying on to come to this conclusion. And I didn't find that as compelling an argument as the Chancery Court seemed to, or the Appellate Court seemed to find. This whole constitutionality of it seems pretty straightforward, right? California has a different rule. They deferred, right? Every state has a choice of law statute that they could follow. And here, Delaware just jumped to the top. So, we're not dealing with that. We're dealing with the Constitution. And California is unconstitutional. So, now we now know that there certainly are, right? What we should take away from Vantage Point is that there are constitutional limitations, constitutional constraints on your choice of law in your respective forms, right? There are those constraints, and they are still in place. And when you're talking about, whether it's constitutionally permitted, like, are you guys having common law this year, or you had it last year, right? So they kind of do this whole, interstate commerce type twisted analysis to come to the conclusion, right, well, does a corporation have sufficient contacts with the forum state? Do they have state interest in protecting the rights of their corporate citizens? Is it going to unfairly impact interstate commerce? And in jumping through that sort of constitutional analysis, they come to the result that, right, if the substitution of the substantive law of the state, of the forum state, does not have sufficient interest or connection or relationship with the claims of the parties, then the other state wins. The other state's choice of law wins. And it does not lay out, for our purposes here, a test by which corporations can rely in making a determination whether they can rely on the state of incorporation's choice of law statute. And that's the problem I have with this is, okay, if you want to take Vantage Point and you want to hold it out as a proposition of here's the guidelines for determining which state laws govern a corporation's personal affairs. I remember you're not talking about conflicts against a third party at this point. You're talking about internal affairs doctrine and determining which substantive law to apply. Right? were either of you able to pull a rule out of this and say, well, what's the rule? How do you apply it? Other than the constitutional test that they ultimately did apply?
I don't even see if they really did even apply a constitutional test. They just said basically that to the Commerce Clause, states can't regulate it. Therefore, the states can only regulate what they have control over. But it doesn't even seem like there was a rule in here other than where you incorporate governs your internal affairs.
Right, to the extent it's consistent with constitutional standards.
Where
Well, that's what it's like, all right? Do you have sufficient state interest? Do you have, and I guess ultimately here, if we just look at it on its face, you've got a corporation. This corporation has investors. And let's just stay California. They're incorporated in California. And these investors said, we're going to give you money, and in exchange for this, we want preferred stock with preferred voting rights weighted in our favor so we can be involved in the decision-making process. Okay, California wants to do that. They then want to merge with another corporation. Right? California and their law, they have an interest in protecting the rights of their corporate citizens. Right? If you are a California corporation, they have an interest in that. And they should, if you want to set up your stock that way and you want to have a say, and that's what you bargained for, and it comes to court because, no, we want to use this law because we think all shareholders should have an equal vote. It seems like, to me, California had the more compelling argument for why its statute read the way it did. But that's not how the case ultimately fell. So, that being said, just note that your choice of law for your internal affairs can be impacted by the nature of the claim and the state's interest in that claim, not necessarily in the corporations itself. Okay. I wish I could sit here and tell you Vantage Point is still good law. I don't know that. But I know it's supposedly the seminal, not the seminal, it is this is the best example that embraces the internal affairs doctrine, and thus it is an excellent place to start with students noting the distinctions that the courts take from Vantage Point. So,
Well, this book's 4 years old, so maybe it's overturned by now, right?
so take those distinctions and let's run with them, right? And how do you go about selecting a state for incorporation?
If you're small, you don't want to be flying to Delaware all the time, right? So you kind of set it up to California or wherever you're at.
True. But you're going to want a stable statutory scheme, right? You're not going to want one that's changing. I say I incorporated because the rule was this, and now you've changed the rule, and what's going on?
Does Delaware change all the time? Or do they
It doesn't, and that's why.
That's why they like it.
Exactly. Right? You want one that's been shaped by a judiciary that has great experience in corporate matters, right? Delaware, right? You want one that there's a network that captures corporate entities as a community. Right? Delaware has that. Yeah, you don't really have that in say California, and you have a commitment by the legislature to keep its statutes abreast with developments, right? What's going on in the law and the area of corporations, and it's those things that make Delaware an attractive place. But those are all things that, when you look at a big corporation, a successful corporation, right, makes sense. When you're looking at an initial startup, are you as concerned about that? Probably not, right? You're concerned about, well, where are my investors and where are my clients, right? And am I going to be right? Am I going to be flying to Delaware? No, I need to stay here in California. So from a practical standpoint, staying local is definitely has its advantages. Okay, so if somebody comes into your office and says, "Hey, I want to start up a corporation," many of the advantages that make Delaware attractive and for larger corporations just aren't going to be there. So just kind of keep that in mind. When you're selecting it, you wanna pick one that's going to be useful and meaningful for its point in time and its usefulness to the corporation. And if you're just starting out, that's probably going to be the state you live in. It's not until you've grown and you start realizing the benefits of being a successful corporation and wanting these other attractive elements of Delaware's scheme that you say, yeah, maybe I want to go to Delaware. And so.
Vantage Point is still good law.
It is good law.
There you go. And the rule according to LexisNexis is the internal affairs doctrine applies to those matters that pertain to the relationships among or between the corporation and its officers, directors, and shareholders. The conflicts practice of both state and federal courts has consistently been to apply the law of the state of incorporation to the entire gamut of the internal corporate affairs. The internal affairs doctrine does not apply where the rights of third parties external to the corporation are at issues. So contract issues and tort issues.
Oh, that's really the issue, right? But you have two different state corporations.
That's the issue, yeah, because ultimately, if this was just an internal affair between Vantage Point, California law weighted the stocks. And Delaware did. Right? So when you brought in Examine, then Delaware had.
Would it matter how the corporation is merging? Is this one acquiring the other, and then the rules will transfer over to the one they acquired, or are they merging equally as partners?
That's another question, right? And they don't really explore that here, but there's different types of purchases, right?
You're just purchasing the company. They're going to follow
you can purchase by way of stock purchase, where you can take over that corporation, and you're getting everything that corporation has, all its assets and all its liabilities, and you basically become, or that corporation becomes you. Or you can just purchase their assets, right? If you purchase their assets, that's what you're purchasing, right? They keep their liabilities. They're still responsible for that. And then they go out of business or whatnot. You take their assets and you absorb their assets into your corporation and you move forward.
That doesn't apply like someone that's just buying stock on the stock exchange, right? Like if, say I buy General Electric, I just keep buying it. And somehow I just kept buying it so much that I'm like over 50% share owner. I don't get the liability, right?
Okay. No, you do not.
It's a different type of
Because you have common stock anyways at that point.
Is that what it is? It's common stock?
Yeah, anything you can buy off the stock market is going to be common stock. You basically have to get it directly from the corporation to have any kind of a preferred stock.
And then, okay, so then the preferred stock is different then.
Yeah, because the preferred stock, so it's like common stock is you have one vote for one share. Preferred stock can be like your one share has like 8 votes. So if you have one share of preferred stock, that's 8 shares of common stock. So your vote is worth more than somebody who has common stock.
So you just control the corporate. No, like, but no matter how much common stock you own, at some point, can you become liable for like the corporation or something?
No, liability, no.
No, because you're a shareholder, you're not on the board of directors, you're not
Okay.
making decisions for the most part. You're just letting the board of directors know this is how you feel.
I was really curious about that.
So, how do you organize a corporation, right? It doesn't take much, right? You need a name for your corporation. You need articles of incorporation. You need to name some officers. You need to name some directors. If you are so inclined, you do not have to do this. And if you don't do it, then the default rule is you just get common stock, right? If you want to have different classes of stock, well, you need to lay that out. What most people do when you're starting up a corporation is you let the default rule, and the board of directors have the authority to amend the articles of incorporation at a later time, and they can amend the classes of stock at that time if they're so inclined. So
There's no minimum amount or maximum minimum amount of board of directors, right? It can be your own. You can make a corporation on your own.
sure,
Okay.
sure.
Because I've seen some people just has their name and then says
Yeah.
private corporation or something.
Yeah, and I'm everybody.
I remember.
I'm the president, I'm vice president, I'm the treasurer, I'm the secretary, and I'm the sole, director on our board.
Then you just have your meetings like when Starbucks drinking coffee.
Absolutely.
Just thinking really hard, right?
Absolutely. So it does not take much to organize a corporation, and you can fill out the paperwork with my mother was trying to call me all day today, and I was busy. I couldn't take any of her calls.
I was gonna call her before.
So she reached out. No, she reached out to mine.
Oh.
And you know what she wanted? Apparently, I butt dialed her yesterday, and she wants to know what I wanted.
Oh.
Yes.
All right. So mom's okay.
Right.
All right, mom's okay. What are the basic types of financial security? Right, you've got your common stock, the cornerstone of corporate law. Right, all of your shares have same rights, privileges, and preferences as all the others. Okay, simple as that. Unless the articles of incorporation say otherwise, common stock are your is what everybody has. Okay, preferred stock, it's a hybrid. It combines an ownership element of common stock and the senior nature of debt. Okay, basic elements of preferred stock is what? What did you take?
From a single point of view. Single point of view. Well, pretty much you owe the money of whatever the corporation is.
The main thing is that you have different rights and privileges as a preferred stock owner than you do as a common stockholder. And those different rights and privileges generally mean you probably have a weighted vote. You probably have a differential in your dividend distributions. You probably have a higher investment into it and a higher expectation of return than your common stock. Okay, so
I'm trying to grasp that. Does that mean, I don't know, it kind of makes regular stocks seem kind of shady now. Like, I'm just trying to get money or something.
you know, regular stock is
Common
it's-
stock, yeah.
there's not much to it, but at the same time, how much, and I'm just throwing it out there, how much common stock do we own that we have no idea, right? I've been investing for years in a number of mutual funds, and every once in a while, I'll get a portfolio, mailed out to me, and I'll get a vote, an election mailed out to me, and I never read it, and I never take any action on it. I assume at some point through my mutual funds, I'm earning rights to votes, and I'm earning rights to dividends, and I'm doing those things. And I assume if I wanted to push the issue, I probably could issue a proxy to somebody to vote my shares if I was so inclined. But most people, when they're investing, they're not really taking advantage of all the rights and privileges they do have, even as a common stockholder. So typically your preferred stockholders are going to be the ones that are involved, and they're involved for a reason, right? Okay, that's my money.
They're running the business.
And I want to keep my eye on it, right? Right, and it makes sense, right? I'm investing in what? What do you got? Right? Maybe you don't got nothing. Maybe you got a great idea, and we don't know if that's going to be profitable or not. All right, so I'm going to give you the money, and I'm going to take the risk, but I want to have some control over that, right? And you're going to give me that control because, like we were saying earlier, what's the alternative? Well, go to a bank. Are they going to give you a loan on your idea, on your intangibles? Probably not, right? It's risky, and right, you're gonna need your investors, so you're gonna take their money, you're gonna give them representation, you're gonna give them preferred stock, and that's what they want because that's gonna protect them against any sort of defaults on a loan. And I call it a loan even though it's not a loan, by you, by them they're not getting their money back. So a lot of these, venture capital firms, they're in and out. Yeah, they want their preferred stock as a hedge against loss, but as soon as you're on your feet and making money, okay, our return, we're gone, and we're on to the next investment. They're not sticking around because they don't have that same commitment to the corporation, right? For them, it's a financial transaction, and that's the extent of it.
So that makes sense because they also they have disposition of assets and liquidation. So I'm guessing if you go out and buy all this equipment and then they want the money back, well, I can liquidate all this, try to get some of my money back.
Exactly. No. There we go. Securities. Types of debt cover. Seductive qualities of debt. Right? Are there seductive qualities of debt?
Yeah, you can write it off. but I mean,
Okay.
other than that,
right? You got the tax shield,
yeah.
right? But there was this, I don't know if I read it here or here, where they're talking about managers wanting debt. Oh, here you go. So you might ask yourself, I'm just going to read this, you know, aside from the tax shield, what are some other good features of debt? One benefit of debt is the discipline debt imposes on managers. The amount of cash flow that managers have discretion is less with debt. So they are less likely to pursue suboptimal or negative value opportunities. Second, managers can signal their confidence about the future by taking on more debt. Thus, leverage is frequently understood as a positive signal.
So they have a lot of debt. They're gonna be, this guy's gonna be risk a lot.
Oh,
You know.
you're doing well. Your financial future's strong. Look at all that debt you're taking on.
That sounds counterintuitive. But
Yeah.
The authors say it's a benefit, so, and they say it's seductive. So we are going to go with it.
You also don't have proofread, so I mean.
No. This is
That's what they want us to think. This is really
Yeah.
bankers and credit card companies.
okay. Equitable subordination of shareholder claims. Okay. What does that mean? Right? Well,
It basically means that if the shareholders put their own money into the corporation, they don't get the benefit of the bankruptcy, right? Basically, they just lose it.
they lose it. Absolutely. Right. And when you go into, right, we've got this mini case.
And in many cases, it was I guess a publishing company bought a newspaper company, and then they turned the newspaper company into something else that wasn't as profitable and it was losing money. Then that company they purchased kind of went bankrupt, and now they're trying to put a claim in there like, oh, they went bankrupt, but we want our money back. And they said, no, well, that's actually you guys. You can't just get your own money back out of bankruptcy.
Right.
So,
Yeah, exactly. So, you know, just kind of keep in mind whenever, I know you guys have heard this through the years, but whenever anything is couched as equitable on the front end, right, I always substitute as fair, right? That's really what you're looking at. You're looking for some sort of ruling or result on a basis of fairness or justice as opposed to an actual cause of action or whatnot. So
I just thought it was a smart
Here.
attempt, but yeah.
here, it's just, right, that it wouldn't be fair to let these corporations declare bankrupt and then
They get their money back
And they
over
get their
actual
money.
lenders.
Exactly. So it would be fair to subordinate their claims below those of creditors.
So basically, they can get their money back so long as they have enough liquidation to pay off actual
Everyone else?
creditors,
Correct.
right?
Yes. Yes.
But then again, if they're going bankrupt, they probably don't have enough.
In theory.
But in theory,
They-
they're still on the list. They're just at the very last on
They're at
the
the
list.
very bottom, right? And common sense would tell us that makes sense, right? That seems like a fair way to do it. You know, the other.
It's like your wife giving you $50,000 as a loan and you filing personal bankruptcy and your wife going, okay, I want my money back.
It's gone.
Yeah.
Sorry.
Sorry, the bank is first.
So, what are the?
This is one of the partnership cases too, right? Where they kind of the partner lent the
Yes.
other corporation $50,000.
Right.
So,
And remember when we talked about partnerships last week, right there, when partnerships are, I always want to say winding down. To me, it seems like
Yeah.
the phraseology, the actual phraseology is winding up. When the partnership is winding up, right? And if you have liabilities to a partner, right, that they've invested in the partnership more than another partner, right? that partner gets paid first, right? They get their money first over the partner that hasn't invested as much. So, there's an equitable subordination of partners' claims whenever the partnership is winding up. But
yeah, with partnerships though, with their equitable subordination, I mean, they're actually elevated rather than
correct. Yeah.
Put down. I mean,
right.
You're brought up to get your share
You
paid
gotta
out.
get your money first. Yeah.
Like a corporation where if you put your own money into the corporation, then they see it as it's just you funding another entity and that entity failed, right?
Right.
So it's kind of the opposite with partnerships, actually. In partnerships, you get elevated, so you get your fair share for the money you put in. Whereas in a corporation,
no, there was a particular case though, where in the partnership where one of the partners put $50,000 into a company, and then when they were dissolving the partnership, he was trying to get those $50,000 out, but the other partner didn't want to dissolve, right?
Right.
And in that particular case, it was like, well, it's in bad faith because you're dissolving this partnership, but you're going to get all this money out of this business. You're kind of leaving this guy out to dry.
yeah, but I think that one was because it was in bad faith.
Yeah,
It's more so, yeah. So if you're acting in bad faith, then yeah, you're not going to get your fair share. But
that was a bad faith case.
Yeah.
Okay. Well, right, if we've got our corporation, right, and we've got it formed, and we know what law we're going to use and whatnot, right? Well, what do we need to have valid action being taken by the board?
Meetings.
You need a meeting.
Yeah,
That's basically what the state stood for, right? You need an official meeting to fire someone.
You can't just have a casual conversation with 4 board members and.
Right. Well, you got to have meetings, right? And you got to have right. There's a whole section of law that is right. You got to have quorum, and there's certain decisions that the board can make. Other decisions have to be made or posed to the shareholders. Any changes in the fundamental structure of the corporation, right, generally need to go to the shareholders, where operational type decisions the board can make. And, though, much like partnerships, when we talked about you can put whatever rules you want in your partnership agreement, you can do the same thing with your articles of incorporation, right? You can affirmatively authorize the board of directors to do certain things that under a default statute where it's not addressed in your articles, they wouldn't be able to. So, but generally for valid action, yeah, you got to be able to meet. You got to have your quorums, and it's got to be properly within the authority of the board. Okay. So.
Yeah, I guess this company was pretty cutthroat, right? We had this guy he held a meeting to try to get 3 board members fired and reelected and replaced. And that was an official meeting, but then the 3 board members had their own meeting to fire this guy and get him replaced, but their meeting wasn't official. So Mr. Fogel's meeting did count, and
Yeah.
you have to have an official meeting. Just because you're a bunch of directors talking in the same room doesn't count as a meeting.
And you see on page 149 there, and the notes following Vogel, you've got just general rules governing, kind of like you said, how meetings need to are guided. And
We had a couple for these. You pretty much sit in a room, there's someone taking minutes and kind of reviewing what happened last time. You guys
right.
put everything to vote. And
Usually it's pretty. Look, you're a brand new corporation, you're not doing any of these things, right? If you're the president, vice president, secretary, and all of that, you're not doing it, right? You're just not. But when you get into the the public corporations and the Fortune 500 corporations, this stuff is just matter of fact. It just happens in the due course, and they've been doing it and complying with it for years. It becomes how you do business. And it's just ingrained in your day-to-day culture of how you operate. So.
And I thought this was pretty cool because I went to the regional occupation program we used to have, ROP radio. Yeah, I was like, I would suggest things and I realized, I actually put money into my suggestions.
So with voting, it says that an affirmative vote of a majority of those present, not simply a majority of those voting, is required for action. How does that make sense? Like, if only some of you can vote, why would you need a majority of those present and not a majority of just those that are voting?
I think that goes in line with notice, right?
Yeah,
That's a
right.
notice to be there for some kind of.
Yeah, but if they're present but not voting, why would they be counted into the majority, like into the pool of those voting?
Because maybe, let me give you an example, but may not right on point. Maybe you've got somebody who has a conflict, right? So they're not voting, but the rule says you need a majority of voting members to rule on any action. Well, they're a voting member and they're there, and maybe on the action that you just voted on, I voted. On this action, I'm not voting because it has a financial impact on my in-laws, and so I'm abstaining from voting on this, but I'm still here. Once you have your quorum in place, you've got to have basically a majority vote, assuming everybody could vote, to pass. Where you can't just say, oh, you're recusing, oh, there's only 3 votes here. Okay, well, let's pass this. Right, and then 2 out of 3 pass it.
Okay.
Yeah,
There still has to be like a majority amount to vote,
right.
but if one person is out, their vote still counts as like a no, or?
Well, no, it counts as a possible, right? So you're on any given meeting, the total number of votes you need to act is set by the total number of voters that are there, period. And that's set. So for this meeting, there's 10 members here. We need 6 votes, affirmative votes, to pass any action. Now, on any given action, you may have 8 voters, 9 voters, what have you.
But you still need 6.
You still need the 6.
Okay.
Right?
Okay, so say 5 people recuse themselves, well, it's just not gonna happen then.
Can't happen.
Okay.
Right.
So I think that's what they mean, like,
Can't
there,
happen.
yeah.
And there's tons of stories how people would manipulate it. Hey, I'm going to walk out for this vote, so that you need less people, and then, oh, well, I'm going to walk out, so you lose your quorum, so you can't vote on this. And people would play games with it. So corporations don't like games, right? Corporations like that stable rules of how you operate and how you can function, and take all the gamesmanship out of it. But this is how many people's here. Here's what you need to pass. Period.
I was just scared to think that you could build a corporation and get booted out of it at some point.
Well,
That's what happened to Elon Musk and
And
Tesla and Papa
Jobs.
John's and
Steve Jobs also really got booted.
no, Steve Jobs I think stepped down because he got sick.
Well, no, that was
He didn't
the
get
second time.
kicked
I
out.
saw his documentary.
Oh, I didn't see the
Yeah,
documentary.
he got
I know at the very end he didn't get
Then he dropped all his shares on purpose to make the price plummet so that they asked him to get back on board.
Oh.
Yeah.
he's playing games.
Yeah, so he was playing games. He just dumped all his shares so the price plummeted.
All right. How do you what do you need for shareholder action? All right, remember when you're talking about shareholder action, you're not talking about the day-to-day operations of the corporation, right? You're talking about changes in bylaws and articles, fundamental changes in how the corporation is put together, right? And maybe in those bylaws, you'll say, we need shareholder approval for X to approve a merger or a sale or whatnot, right? Your articles can lay out whatever rules you think are necessary and appropriate. And you set your corporation up how you see fit. So,
And that's when you get those little pamphlets in the mail, the voting, right?
right. So what do you need for shareholder action?
Notice quorum voting and
Mm-hmm.
that's it.
Now this is they have a different standard, right? So here, right? Let's just say you're trying to change a bylaw, right? You've got 600 shareholders, 300 vote yes, 200 vote no, and 100 don't vote. They abstain. Okay. Now assume also there's 1,000 shares that are entitled to vote. The default rule, okay, the Delaware rule, the Model Act rule states that a majority of the shares present or represented, by way of proxy or whatnot, constitutes a quorum, and the resolution is approved if a majority of the shares voting approve. So if you got
200.
1,000, right? If you got 1,000 potential votes, you need 501 to constitute a quorum, right? If you have, let's say you have 600 there, because that's how it breaks up, and then it's 300, 200, 100, right? The resolution would be approved if a majority of the shares voting approved.
So these
Does that make sense?
full quarter, yes.
Yeah, so you need a majority of
Those that are there in the
Those-
quorum.
right. So it's possible voters for your quorum, it's majority of actual votes for the passage. Okay. Election of board of directors. All right. How do you go about that? Right. This talks about staggered boards and
Well, it's still voting, right? So
what's a staggered board? Victor?
staggered board.
Staggered board.
I'm looking at a table two. No idea what it is. And is that how much their stock has declined under the rule or something?
No, staggered board is a board that is divided into 2 or more classes, right? Each of which is elected separately for staggered terms. I'm looking on page 152. Right, the rationale for it, right, basically you don't have the whole board coming up for election at the same time, right? You have a certain number of board members, their terms expiring in 19, right? Then you got another group whose terms are expiring in 20. Then you got another group that's expiring in 21. And then the group that you just elected in 19, they're now going to expire in 22. however you set it up, but something along those lines,
Just like Congress.
kind of like Congress.
So, they'd have to re-vote you in again, right? So you can't get booted out of your own corporation if you do a bad job.
Right.
It's terrible.
The idea is, right, it promotes continuity, right? The reality, right, just using a congressional example, if you just say, you know what, all of you are out there, you're all new. What the hell do we do? You know what to do? I don't know what to do.
No one else.
You know, I was going to rely on this guy who's been here 30 years. He's gone. right? But if a third of you are brand new, well, 2/3 of you got some experience and kind of know what's going on, right? And then when this third leaves, well, these guys now have some experience and can provide better stewardship and guidance to the actions of the corporation. Okay.
No, are these elections are they mandatory or is it how you're written into your bylaws? So,
Here's
what if like the board itself is actually just doing a good job and didn't leave re-elections?
Well, here's the thing. Every state has a default rule.
Hmm.
So either you're going to put it in your bylaws how your board of directors are going to be elected, or you're going to be guided by the default. Okay? And a default may be, right, you hold elections when an opening is there, right, when needed, when there's a position to fill, what have you. I don't know what California's default is, but I could tell you every state has a default. And that's why you can literally form a corporation with next to nothing, and you'll be guided by all these rules.
Makes sense.
Okay.
Yeah.
If you don't want to be guided by the default, then you put in the parameters that you want to have your corporation run by.
Can you secure your job for life through these parameters?
Well, that's part of the criticism of staggered boards, right? Is that in essence, you know, you are creating a sort of entrenchment of the directors that they never leave, right? Even though they're staggered, you know, they still potentially just continue to get reelected. Right? So let's talk a little bit about Marcel Kahn and Edward Rock, the embattled CEOs, right? So what happened to their companies?
This was just like an article,
Right,
wasn't it?
it was. But what happened to these two guys?
I don't know, I skipped it because it's an article.
Oh my! No,
I was trying to get through it and I'm like, oh, it's just an article. They're usually
I saw it
useless.
again, because then I just saw it again. Again, Marcel was the same company over again. A couple times.
Okay, well, basically these were cautionary tales about how,
Yeah, the book didn't seem to like staggered boards.
how staggered boards actually serve as an entrenchment device, and how it is losing favor amongst modern day corporations.
What is wrong with entrenching devices, though? I mean,
Well, because then the company never changes. And that's kind of the argument with Congress, too, is it doesn't change.
but this is a private company. What if you don't want it to change because it's your life's work?
Yeah, but some people do. I mean, if you look at the Ford case that comes up, I mean, they were sick of how Ford was going, so they wanted things to change. But
Is that how Musk got booted off his SpaceX or something? No, he got booted off.
he's still there, but that's what they wanted to get rid of him for because he was doing bad things to the company.
Smoking and
Well, yeah, he was tanking shares and stuff and like the value of the company. But yeah, I mean, most of the time you probably want a corporation to stay course, but there are times when it's just being run so badly by those that are in power that you eventually want to
I
get
guess
rid
it
of
makes
them.
sense, because once you get to that point, you're playing with other people's money, it's not just your own.
Well, yeah, and that's what the later cases were all about. Is it was shareholders saying, "Hey, we gave you all this money. We want you're running this company like crap.
Yeah.
We want some say."
Okay. That makes sense.
All right, let's take a stroll down voting road. Okay, so we're gonna do an example. Okay, so I have never used our board before, so let me see if I can get this to work here. Okay, we've got Sally. She owns 700 shares. Bill owns 300. They're the only shareholders. Okay? So Sally nominates M, N, and O for the board of directors, and Bill nominates X, Y, and Z. Okay? Under straight voting, the maximum votes each can cast is the number of shares owned multiplied by the number of directors standing for election. Okay? So in this case, we got 3 open slots. Okay? So for straight voting, Sally
4,200.
has 3 open spots, 700. Sally has 2,100 votes.
Is it just for the votes she nominated?
No, that's how many votes she has.
Okay.
Okay, and Bill would have 3 openings.
900.
He's got 900 votes. Okay, that's for straight voting. All right. But under straight voting, the maximum that can be cast for any single director is the number of shares owned. Thus, Sally will cast 700 for each of these guys, right?
Each, so 777.
So that's the most you can vote for any director is what you actually own. She's got 2,100 votes. She can vote 700 for each of them. So what does Bill do? Right? Bill's nominees, they're going to get 300 each. Right? So Bill doesn't really have a share. Right? So if Bill votes 300 for each of those, who's your board of directors? M, N, and O.
I can tell that from the first one. It's like
Sure.
700. Yeah, it's true.
But for whatever reason, just keep in mind, this is for straight voting,
Mhm.
right? In straight voting, whoever owns the most shares is going to win. Okay? Plurality voting, because keep in mind, under straight voting, the most you can vote for any one is your maximum number of shares. So the most Bill can do is give each one 300.
So these are 3 different positions, then, right?
Right. So Bill's under straight voting, Bill doesn't have a say. Under plurality voting, right, the directors receiving the highest number of votes for the number of open position wins. Thus, the winners here are M, N, and O. Okay? There's nothing confusing about that, right? Straight votes, it's the most they can get. They're the highest vote getters. Highest vote getters win. Okay? So, is that how you want to be organized?
Nope.
Well, if you're Sally, absolutely.
Yeah.
Right, if you're the main vote getter, I mean, the shareholder, yeah, you want straight voting.
It's just
Okay.
two, it's a partnership, and not a Bill's favor, it's not a partnership.
Right. But if, right, you want to mix it up, so under plurality, highest votes getters win, right? And there's nothing you can do, right? Bill's got 900 votes, right? Conceivably, right, he could pick one, and say, I'm gonna give X. X is who I really want, I'm gonna give them all 900 of my votes. And maybe get one board of director, but not under straight and plurality systems. So, in a cumulative voting system, okay, there is no ceiling in a cumulative system, right? So there's no lid up there. It's not 700 per, 300 per. It's I've got 900 votes. In theory, I now pick my person, right? X is Bill's horse, so he's given X 900. Seems fair, right? But what is now? These
When
two,
Sally gets
these
six,
two
Bill
get
gets one vote.
0, right? Sally says, well, you know what? I like M. I'm giving M 901.
And then split.
Right, and how much does she have left? A lot. Right, she still has
11.
11.99. Right, so she's got 11.99, and these two guys, right, one of them gets 500, and the other, right,
$6.99.
6.99.
So then the one with 699 has become third, and at least
Right.
Bill gets one person he
Right,
likes.
so Bill, under cumulative voting, can get one person on the board, right? And Sally basically picks who she wants to fill the other two spots. And one of hers doesn't win.
Well, it still looks like she gets everyone.
Well, no, because
No,
one only
because-
gets 500,
Right?
which is still less than 900.
But if Bill put all his votes into X, then does he have any votes left over for the 500?
Then this is your top vote getter. This is your second top vote getter.
Well, no, because that's out of a pool of 6. So Sally likes 3 people, Bill likes 3 people, but it's still a pool of 6.
Oh, I thought they were fighting for 3 positions.
Well, they are.
They are.
So there's 6 people fighting for 3 positions. So M gets, I can't remember how many.
And
M gets 901. X gets 900 because he gets all of Bill's. And so she has the 11.99 left over to split between either N or O, or to put all on either N or O. So either way, somebody's going to get less than the 900 votes that X has.
No, well,
So they're still going to.
I thought, if M has 901, he just knocked X out, so X isn't coming in.
Well, no, because
Top 3
it's
vote
the top 3 get in the board. So you have 901,
Oh, I see.
900, and then whoever gets the next third amount of votes.
Okay, so yeah.
So it would be
two versions of the top 3 then.
Right.
yeah, 2 on the top, 1 on the bottom.
And ultimately, Sally's going to have to pick how she's going to divide her votes, right? Because she doesn't have to vote 901, right? What if she just gave all of them 700 still? Well, then you got a 3-way tie for second and third. Bill would be your top vote getter. He would still get on the board, but then what's going to happen to the other 3?
Runoff.
There's a tie, right? There's got to be a runoff.
And then
So
Bill's going to
what's
vote again.
right? So what's going to happen, practically speaking, Sally's going to know, and she's going to say, I'm going to give one of these 701, and somebody's going to get 699. And I'm going to pick the 2 that I really like. So cumulative at least gives you the opportunity to get a representative on the board of directors. Okay? Now this is, just keep in mind, this is a 2-person field. Now just, the voting still runs the same. So just imagine you got thousands of voters who have any number of votes, right? And any number of nominees, right? There's going to be coordination. There's going to be block voting. There's going to be proxies given. Hey, you give me all your votes and I'm going to make sure that Bill gets in. We're pooling our votes for Bill. Okay? And, you know, so it's still, but what I want you to understand, under straight voting, right, you get 3 times, and under but you can only vote your maximum for any one candidate, what you hold. And cumulative, you can spread them out however you want. And under plurality, it's the highest number wins. Okay, so you know, you still, the top shareholder still has the most representation on the board. Okay, and ideally, it's whoever you nominate that you think are going to be representing your interests and your investment on the board. Okay, so
Seems fair.
sure.
As long as you're number 1.
And
Yeah, so, well, you own 2/3 of the company, you own 2/3
Yeah.
of the people you want to represent you, so.
so how do we remove directors?
Difficultly,
Difficultly.
unless you're a
Yeah.
shareholder.
We changed the locks. Okay, good.
Basically, you need cause. Okay, and if you got cause, then you can try. But generally, most directors have protections against removal.
It says you can't remove you can't remove a director with or without cause. Oh, the board cannot remove a director.
Right.
The shareholders are really the only one that can remove a director.
And of course, if you get into the courts to try and remove somebody, then
It's a crapshoot.
it's a crapshoot.
So
Right.
a preferred shareholder can remove it.
Well, no, I mean, if you get a majority of the regular
Okay.
shareholders to outvote a preferred shareholder, then you're good.
Oh, that's why in the previous case you had to call a meeting to get these guys reelected.
And, you know, ultimately, I mean, when you think about it, you don't want situations, right? These are elected. You don't want to necessarily be second guessing their judgment. And then,
Still feel like you should be able to remove them for cause.
right. Well, what
It's
you
weird that the board can't.
Yeah, you tell all the shareholders, this is what he did, we'd like to have you revoke, and then they vote.
Yeah.
And if they're cool with him, smoking weed and looking at anime, then she can keep running Tesla.
Exactly.
So,
But so, is there any? You actually. Is there any case law in California that, as far because the case that they give aren't out of California?
I'm sure there is. I mean, I didn't look into it, but I'm sure that there's case law in California that talks about, removing directors. And generally, if you're going to court, it's gonna be for cause,
Yeah.
right? You're not gonna be removing them. I don't like this guy, right? You're gonna have a reason for,
Because it's probably part of like a tort action or a contract action, right? I
right?
mean, just
Because right, your directors have many of the same duties that we've been talking about for agents and for
the
partners,
fiduciary
right? You've got
duties,
your fiduciary duties. You've got your duty of loyalty. You've got your duty. I'm drawing a blank. Best business
Oh, financial?
Yeah, that's
like
it.
financial savvy?
Yeah, like you're making good financial decisions based on the information you have. There's a phrase for
Like the
that.
prudent investor standard or
Yeah.
whatever for wills and trusts. Like,
Exactly, yeah. Yeah, it's something like that. There is a phrase for that, and it's in one of these stupid outlines. Yeah, but you've got a duty to be making sound financial decisions, and it's got to be based on what you have.
which have knowledge of, yeah.
Yeah, what information you have in front of you. So, so what might not look like a good business decision, when you look at what you're basing it on, it's like, oh, well, yeah, if that's what you based it on, then that makes sense.
Mhm.
So, how do corporate officers take action? Right. Well, remember, you may not even have corporate officers. Right? Or you might have one. Maybe you don't have a CFO or a COO or a CEO. Right? So, right. They give a nice breakdown of who the different corporate officers are and what their general job description, job duties are. But just keep in mind, depending on how your how your corporation is organized, you may not have any of these, right? You may have one person, one officer, right? You may have two. It's got to be based on what you're organized, how you're organized, and what authority they are given by way of your bylaws. Okay, if you have a president, right? Your bylaws are going to have to lay out what authority you give the president. Well, I'm going to have a chief executive officer. I'm going to have a chief financial officer. I'm going to have a chief operating officer. Okay, what does that mean? How do you differentiate that? In the absence of affirmative direction within your bylaws, then you're going to look to, well, what are the acceptable duties across the spectrum from a president, right? What duties does a president of a corporation typically hold, and what actions are typically authorized for them? Okay.
So it's funny because I hung out with the corporation once, and like one of the ladies that she didn't seem too qualified was like, yeah, she's the president. I'm like, this is a big corporation. I'm like, yeah, I didn't realize she didn't really have that much authority. Like, she just kind of appointed her as president. Turns out I couldn't have as much power. It's only how much they were gives.
Yeah, it's funny that they mentioned banks in here for like vice presidents because my branch manager is a vice president, and I'm like, yeah, that's true. They give that title to everyone.
I sound like, really? But it sounds super
No,
impressive.
they do. Yeah, she was the vice president of our branch, and I'm like,
I'm sorry, guys. I just now realized we're past 7:30. We got about 15 more minutes. You guys want to take a break? You want to power through?
I'm good to go. Unless you want a break.
Power through.
Okay. All right. Ultra virus doctrine.
It's no longer applicable, isn't it? At least that's what the book seemed to say.
Well, yeah, it's largely historical. Okay. But the concept is still there. Okay. Generally, your articles of incorporation are supposed to identify what you do, what your business is, what your corporation all about. In the absence of a description, the default is
Whatever the code
any
says.
lawful business, right? You can't engage in unlawful business. So any lawful business is acceptable. So
No crime syndicate.
do you want to limit your corporation by saying this corporation is formed for the sole purpose of selling, you know, Star Wars action figures, right? And then as soon as you say, well, I'm going to start selling, you know, video games,
You're SOL.
you're ultra virus right there, right? You're engaging in things outside of the scope of this corporation. Because of the negative ramifications of specificity, most corporations are vague, right? To allow them more flexibility, basically to engage in whatever profit-making opportunities present themselves that they want to. As long as it's legal, they want to do it, okay? So, you know, it is, for the most part, I think most attorneys, when you come in and they say, hey, well, you're supposed to list this right here, I gotta tell you, let's be broad, let's be as general as possible.
So on the forms, there's a section that says, what's this corporation for? You just
Yeah.
leave it blank.
Well, if you leave it blank, the assumption is it's any lawful business. However, if you leave it blank, you run the risk of somebody just running them up, right? There's no direction, you've given none, and so you set up a corporation to, you know, I don't know, you want to print documents, but you left it blank, and so now all of a sudden you're doing, you know, llama tours down in Argentina. It's like, what? Who approved that? That's not what we want to do.
Too bad.
Well, you didn't say. So it's a lawful business, and your officer decided, I want to try and make money in this way. So you limit by giving some generalized description, you do put some parameters on it. Okay.
How profitable is this llama tour business?
Welcome to Pepsi Llama Co. How can I help you?
Sell beverages and we do llama tours.
Yeah,
The
llama milk. Cool.
So, yeah, for the most part, it's a non-issue, and it's mostly because it's just been gone away from, because of the limiting nature of it.
I liked how it said that corporations used to have like multi-page, like this is what our corporation can do, and I feel like it just got excessive.
Right. Yeah, and because what would happen is, to avoid the ultra-virus issue, they would amend their bylaws, right? Their articles, and they would come in and they say, we want to engage in this. We want to take advantage of this opportunity. I'm not sure we can, given our current state. Let's amend, and they would add it, right? And then something else would come up, and they would add it.
Yeah.
So to avoid that, we can do anything lawful.
Yeah.
So wait, what happens if you go beyond what you wrote in your application?
Then technically a shareholder can sue to have that action undone,
Makes sense.
saying that you've gone beyond the scope of your authority.
Okay.
Right.
That goes into something I want to talk about. Like, that's what happened to Google, right? Google started focusing on robotics and stuff, but the Google shareholders say, no, just do search engines. So they branched off and started abc.xyz. And yeah, so okay.
Just focus on searches.
Yeah, that's
Where's the
exactly.
money in that? I'm sure there's a ton of it
AdSense
now,
revenue
but
and-
Now, yeah.
back then though, I can't. Like robotics seems like it was a much better option than
Seems cool.
Search.
No, search engines, they gotta know what you want before you know you want it, and that's how they make the money.
True.
Which is terrifying.
All right, the objective and conduct of corporations. Now, I have been told that Dodge v. Ford, the authors told me in this right now, Dodge v. Ford is a classic corporations case that you need to have an understanding for. In fact, on the very first page, they said that I could spend, I take that back. Given the importance of Dodge v. Ford, this case should be a centerpiece of what you choose to wrap around it. So let's take Dodge v. Ford and let's make it the centerpiece of our discussion on the objective and conduct of corporations. Okay, so what's our issue with Dodge v. Ford?
Ford thought that he was making too much money, and so instead of giving shareholders these exorbitant dividend payouts, he said, we're going to reinvest it back in the company, make cars cheaper, that way we can sell more and more people can have access to them. And the Dodge brothers said, no, we want our money. That's why we invested in you, like, we want our payout. And so the court said, yes, there's a philanthropic aspect to corporations, but when you're doing it as a detriment to your shareholders, it becomes excessive, and you have a duty as a corporation to your shareholders to pay dividends, basically. You can't give away your company at the expense of your shareholders, basically.
Right. So it makes sense, right? And there's got to be that balance. You've got to be able to reinvest to grow, right? And just some of the corporations we've talked about it, whether it's Musk or Google or whatnot, right? Their growth has been generated by their ability to take new and expanding areas and throw money at, and develop them into their own independent, successful portions of the corporation. So Ford was, that guy who had the vision, and he wanted to really expand it. And that's something that corporations should be allowed to do. Case says to an extent, right? There's limits. You can't just never give your shareholders any dividends. So you give them dividends, right? And you got to find that balancing act. Okay, and most corporations now have guidelines for when dividends are distributed, not necessarily, hey, how are we doing? We doing good? Let's give a dividend, right? There's standard conditions and standard metrics in place that they can measure and say, okay, this is something that it's time, right? We've got this growth, we've got this profit, we've got this much earned, we're going to give this percentage dividend, and then they move on. So they kind of take the whim, if you would, of Henry Ford to say, I don't want to give a dividend, I want to reinvest it. And they standardize it.
Just think how much cheaper cars would be if this case was allowed.
How much more traffic?
Everybody has a car now.
So, notes on other constituencies under Delaware law and other constituency statutes. We got different approaches. Many apply only in the change of control setting. Okay.
We're just going to tell you about Illinois.
Yeah.
We're going to tell you one of the 33 states.
Exactly.
And that's it.
And I don't know what California is. However, okay, but Illinois is consistent with the Model Act. Okay, so that's going to be similar across the country.
It basically just says you can do things with an eye towards long-term benefit of the corporation, right? As long as you're acting reasonably.
And that is in response to the issues that were raised
And for
in Ford, right? You've got other constituencies that you need to be concerned about. And it's not just your shareholders, right? So what did Delaware do? Right? Yeah, right. Revlon, for example, allows serving other constituencies when the decision also advances the interests of the stockholder. There's eBay v. Newmark decision, which is in the note summarized, and it does not waver in holding that while community service is a great idea, when the founders of Craigslist opted to be a for-profit corporation, it became bound by duties and standards to apply to corporations. Generally, these duties include the duty to promote the value of the corporation for the benefit of its stockholders. So, you've got decisions that basically cut both ways, right? But just know from a standpoint, you can still do both, right? You can still invest in the corporation, and you can still take care of your stockholders, and you got to do your best to find that balance. And what most do is they put their standard in writing, and then they just follow it. So, flexible purpose. Oh man, flexible purpose. Okay. AP Smith. We got one more case. We out of here. What's AP Smith about?
greedy old men.
True.
Old men trying to get back to, it's just trying to get back to the community. Shareholders not liking it.
Yeah, for real. They only tried to get $1,500.
Yeah, that was too much, man.
Yeah, too much.
It's a lot of money in 1953. That's like,
That's not even like a lot. Well, I'm sure it is.
it's like
but
$20,000.
still.
Right, so they want, they wanted to give more, right. This was pretty much what Ford was scolded for, right?
Yeah, and this one they said it was okay. I was trying to figure out if it was because it wasn't too much, or because they're trying to make, because during the time they're trying to get the government, they're trying to get corporations to give more, trying not to be like
Sure. Right, but they justified it because they said that the corporation was being a responsible and enlightened citizen.
Yeah, exactly. So now it's
It's a
okay.
change in the times, basically. Argument. It said back then corporations were them and themselves, and the public didn't rely on them. And then World War I happened, and corporations stepped up and started helping. And then World War II, they continued, and now it's just standard for corporations to help, as opposed to back when Ford was brought.
Okay, so this was like 30 years later. So
Yeah, because Ford was
1919.
Yeah, 1918. So I
It
mean,
was 100 years ago.
yeah. And they spent a lot of time talking about how basically it doesn't act because the statute was enacted after they were created. But isn't there some kind of retroactiveness to statutes anyways? Or, because in here they talked about how, well, there were other statutes in play that says that corporations have to apply with times and stuff like that. But even when a statute is applied, doesn't it get applied retroactively?
Not unless it's
Not unless it directly says so.
Right. Yeah, if it doesn't say it,
Then you're like grandfathered in.
then it goes.
Your crimes are grandfathered.
Then it goes from its effective date.
Okay.
Okay. Some statutes, when they're passed, will say this applies to corporations already in
Correct.
effect
or something like
Correct. So, And if the statute doesn't say, then it is not retroactive.
Okay.
Okay, but, just something you gotta keep in mind. We talked about the ability of the corporations now to expressly lay out the parameters for charitable givings, for dividend payouts, for reinvestment in the corporation. That none of that stuff is left for chance with the big corporations. That stuff is all laid out, and what they do is they have what are called reserve clauses in their bylaws, where they reserve these powers and authority to the corporation that the statute might not give them.
I mean, nowadays you donate, like your corporation gets doesn't pay that in taxes for what they do.
So they get a tax break.
They get tax
It's a
break, right?
deduction.
Yeah, is there a tap on those?
Well, charitable
On charitable donations?
giving is 4,000.
Yeah, there are.
Well, I know for
There are
persons it's
corporate
4,000.
limits on giving.
I thought you could give like $1 million bucks.
You can give When you're ultra wealthy, you can give more. But I know, like, for the average person, it's like 4,000 or something like that. You can give tax free a year.
So,
But I think corporations and like the ultra wealthy get like an unlimited amount because they're already taxed.
And we got the Citizens United that came down. Said you get to give to political.
Yeah, that is charitable. Well, yeah, but that was
It's kind of charitable.
that was more political
It
contributions.
is political contributions, but it's corporate political
Yeah.
contributions. And, right, it said you can do it.
That's because corporations are people.
Well, that's what everybody's been telling you, right? You see them sitting right here.
Why are they given like person? Do you know why they're given person status?
Because because you need it for the ability to transact, to sue, to engage in purchases, right? You need to have
Because they are their own legal entities, so
Right.
they need to be recognized
and
as
if they're
such.
not recognized, then who do you sue?
Yeah,
Right.
You sue the
You gotta
directors,
sue
you
the
can't
board.
do that.
Oh, wait a second. I thought the whole point of a corporation was you couldn't
Yeah.
sue me. So
If you get sued along with a corporation, can you say, "Oh, I'm not part of this"? Or how's that work?
well, it depends. I mean, there's ways to sue individuals involved in corporations, and
So, no, I'm just thinking like simple case. It's like a slip and fall at Walmart. Can you put the name of the CEO on your form?
no, they wouldn't be liable.
So it wouldn't make sense to put them on there. They'd probably just discuss that.
I don't know if it would make sense. I don't know how you hold them accountable. But I think on a complaint type issue, you probably do, because you throw everybody on there.
Yeah,
I'm suing you and all your officers and a whole bunch of does.
and they can fight their way out through MSJs.
Yeah, just in case.
Oh, we talked about this yesterday. Drucker, like the guy with the pharma, like
Yeah,
the
that-
insulin. They're trying to sue the family members that aren't even involved in the corporation or something.
well, no, they're trying to sue the family members, but I think the argument for that is they probably have a lot of say in the pricing of the products because they own the company.
Right.
Therefore, they're liable for the price increase on a personal level because they're the ones directing the company to increase prices. So that's a way around it. But as far as like a slip and fall goes, unless they're there saying don't check floors anymore because
Right.
it's wasting us money, they're not liable for it. They just own it.
Business judgment rule.
Oh, I was like, okay.
I just read it right now. I was like, oh, business judgment rule.
But is it the reasonable business judgment rule or is
It
it
is.
just the business judgment rule? Because I know everything has a reasonable prudent person standard.
I think what the business judgment rule incorporates
Oh, is
is a reasonable standard.
business owner?
Yes.
Okay.
So, guys, I am going to send you crap. And just know that you have no obligation to read or look at or take anything from it. But I have found it useful. Okay, and because I have found it useful, even though it's dated, I'm going to send you those outlines, and you guys do with it what you will. If you find it useful and you want to go through it and consider it as study material, then knock yourself out. If you don't, then you have no obligation to.
So what can you tell me about like holding companies? Because I was curious about those. Because they just, their whole purpose is just to own shares in other companies, right?
Right.
Is that pretty much it? Would you still file as like a corporation?
Well, sure you. Yeah,
Just call it a holding company and say this is a corporation?
Yeah, but even holding companies, I think, are still corporations or LLCs or something like that.
Right. Right. It's just a different. Right? There's businesses out there that are engaged in any number of things. We're going to hold your stock, right? We're going to venture capital. We're just going to give you money, right? And then we're out as soon as you get on your feet. There's all of these businesses that aren't really in the business of doing anything except
Managing.
managing different things.
Yeah, no, because I really like Google's workaround because that's what they did. You know, the Google, the shareholders, they said we just wanted to focus on search engine optimization, and they're like, okay, well, we still want to do robotics, so we're going to open up a corporation that owns the Google stock, but it also owns our robotics stock. So we, from the holding company, we can control both projects, even though this is its own separate entity now. Yeah. So that's pretty much what they did. They just incorporated and say, well, now this holding company owns like the shares of this Google.
Right.
And then they can still control that, which is down the chain.
Right. So and they're still bound by all the same rules.
Yeah.
They just have different assets that they're holding on to. They have different job that they're engaged in. They have different boards of directors. And
You just have the board of directors. They probably have one guy holding two jobs, right?
probably.
All right. So the CEO of ABC and also the CEO of Google.
Yeah, I don't know how they're laid out, but
Yeah. So I just thought that was.
well, I'm glad Vincent's back because I felt a whole lot better tonight than I did with partnerships. And, so, you know.
I don't plan on being out anymore.
I'm hoping to do that.
Thank you.
All right, guys.